So I'll briefly say a couple of words, just what we do in this lab we have in Zurich. So we have an experimental jurisprudence lab there. It's focused on mental states. We're particularly interested in doing things that matter not just to philosophers. We do relatively little metaphysics, but things that might have a real world application. Okay. And one of the questions we work on or have been working on for the last 2 or 3 years and will continue to work on is the question what kinds of biases afflict mens rea descriptions. As you know, mens rea is a term of art or an imperfect state of mind such as an intention or knowledge or references. So we want to figure out how they work, how and whether they can be alleviated, and how we could make proposals to several legal systems to make things more just. And we're just starting to look at causation as well, because we've spotted a few complications there too. So we're basically a small group of people focusing on what can go wrong in court, you know. So here's a team, you know, some of the team members. There's Levin, there's Isa, there's also a guy called Jan Garcia Olier and Martin Vincent. Maybe you've seen them at conferences. We collaborate with a lot of other people. Some are legal experts such as Tinio, others are experimental philosophers like Edouard Machery. Clark Barrett is a very well-known apologist. Sacha Bourgeois-Giron is an economist and so forth. What I would like to do, so first of all, if you're interested in, if you have an idea, so like with Pavel, it struck me as a good idea to have this session early on in the week, so maybe we could, amongst ourselves, develop a couple of studies that interest you, you know. But this idea came a little too late when the program was already set in stone. So we're having this on the last day. And you might, I mean, I hope to trigger some interesting intuitions in you, and maybe you say, there's this interesting legal problem which I would like to test. If you have something like that, get in touch with us, or like, I don't know, me, Isa, or Levin, and we can work on this together. And rather than sort of doing this super top down where I say, ooh, you know, experimental jurisprudence is this or that or whatnot, I thought we just start with an example. So I'll give you a little study and you can do it. It'll take about 4 or 5 minutes. You can do it on your laptops. You can also do it on your phone. It's like not as convenient on your phone, but you know, you get the gist of it. Okay. The one thing you should do is, so I have left all the annoying bits of the study in. Okay. So you really have to read everything attentively, otherwise instantly you're going to get kicked out of the study. Okay. So I'm really giving, like, I'm not giving you a special version, like the cool little version for like the expert people who will be attentive and whatnot. I'm giving you the actual version we run, because then you, I mean, that's probably going to answer a few questions like, ooh, what if people just click randomly and so, you know, so you're going to see the real deal. But if you don't pay attention, you'll face the same consequences as these people whom we usually pay, who don't pay attention, like boom, they're kicked out, they can't take the survey. Okay. So I'll show you a link. It is this one. And if you're on Zoom, you can perhaps just click on it. Otherwise, I do think annoyingly it is case sensitive. Okay. So if you could all take out your phones if you don't have a laptop with you, and click on this link.
Sorry? I think it's over there in the wall. It's 1, 2, 3. CAAS. And then in German called out, it's like the hashtag.
I hope we don't run into complications since we all log in via the same network.
No, but 1 and 3.
Yeah, 1, 2, 3, and
Does the study work for everyone?
the vectors are on the Wi-Fi. What the network is called, it's CAAS or something.
All factors.
I think it needs to be small. No, it's small. That's for CAS3. That's the network.
We pay for the situation.
Yes, like everyone else, you get 40 cents.
That works.
So take your time with this. We're gonna like take 5-6 minutes. Let's start with
I think I failed the first question.
yeah, exactly. Okay.
I didn't click on anything and I copy pasted it.
Ah, yeah. Did you still fail?
I didn't get any code or anything.
That's You want to try again?
Yeah. Just run my VPN. I'm sure I'll get it again.
We can do this. Does the survey work for some people or not?
Yeah, I mean,
Okay, good stuff.
You also tell the attention check. How does everyone on the side stay with the attention check?
Yeah, then I mean this is sort of the first response to your question. How can we make sure that people are actually paying attention?
Through your also basically said, if you read this question, obviously you don't answer that part. And then in the bottom field, we need to write a specific price. You write it with the quotation.
Yes.
That might be the issue. I'm not sure.
it's with quotation.
Is it with?
Yeah.
Yeah.
That's why it says explicitly with the quotation marks. You know.
I guess. Yes,
I'm also
sorry. I mean, you know,
Jesus, you want to do it with the press off the back. If you have a phone or a laptop, we're currently taking this study, so we can
select any of the 3 options on the front.
So I wonder whether quotation marks mean the same thing.
That could be.
So it's a British note.
I don't know if possible.
I'll try to. Yeah, so we will just starting out like this, and then we will try to take it. Seven. That is pretty simple. But people are getting paid for the role that they're taking a task and getting paid for it. It's just the assumed to do the task properly.
we'll see. Let me try to copy them. Okay.
This is 40 cents we get.
Depends how flush I'm with funding at the moment, you know, so this is about 40 cents.
I'm not sure if I.
We're actually like bonds, so did anybody like write it off, automatically completes the detail funding, and so on?
Say again?
I mean, did you encounter any sort of attack? Yeah. Did anybody like write it off to the fund process?
I mean, the bot will precisely not pass the attention check.
There's also more like, for example, bots have certain click behaviors, and there's also, you can also filter for clicks, like there's some people that click 100 times on a blank page. So, if you see that, then it's most likely nice. You can also filter by time.
I think maybe Markus will talk about that.
I'll rather not get into it.
I asked the question about the demographic question.
Absolutely.
If I have a professional degree and master's degree, which one is considered to be higher?
The one that's lower on the scale, I think, is higher.
So you consider professional degree to be higher than doctoral degree?
Maybe we don't.
I mean, these things vary from country to country. You know, this is tailored to the US system. So I mean, put whatever you want. I'm not going to use this data. Okay, this is just for you to like go through a proper example.
Would you have intuition? I'm not sure.
So we'll take another few minutes. I see that only 7 people have completed the survey. I think about a third is not doing it, so we'll wait to about like twice that.
Yeah.
You're all extremely slow. I mean, you wouldn't be good interpreters, you know. You would. they go through this really fast.
Yeah, but we're really thorough. But how do we know that we finished?
How do you know that you finished?
Yes.
Well, I see the responses.
Yeah, but how do I know that it's the last? If there is no go further.
I mean, you should see a code at the end.
Yeah, so that's the end.
That is the end, exactly. Then see, as an online worker, what you do is you take that code, put it back into the recruitment platform, and if the code is accepted, boom, you get your 40 cents or $1, depending.
I have a problem with close. Does not work. There is written the bank already completed the survey.
Okay, so this might see, so that, okay, interesting. So there's this what we don't want is that people take the survey over and over again. We don't want 100 data sets from the same person. So there's a feature called ballot box stuffing, the blocking of ballot box stuffing, which means people can't take it twice. Okay. Now we might have that problem a little bit because we log in through like a single network. Okay, so if you have that kind of a problem, that ensures that people don't do it multiple times. But like here, it's maybe a little complicated. Okay, maybe you want to get to the end. I imagine you get the gist of it, and we get started properly. Isa will have let's see how many people do we have. 22. Isa will do like a little analysis of our classroom data, and later when we're going to talk about reasonableness, we can compare our results. I mean, you're an expert group now to their results. Yeah. So we're not actually talking. We're not actually only talking about experimental jurisprudence. We're doing it in this very room. So the plan for this afternoon, I don't know how long everything takes. So here are a few things I'm thinking about, like talking about. We'll start with the lobe effect. We then move on to something called the severity effect, and both of these effects focus on sort of, the higher echelons of the mens rea catalog, mainly intention and knowledge. Then we look at the less inculpating mens rea types, recklessness and negligence in particular, from the perspective of the philosophical problem of moral luck. We talk a little bit about the hindsight bias. Isa is going to say a few words on that. Then we'll probably move on to the reasonable person standard. This is the kind of experiment we just completed here. And if time allows, which I hope, we'll also talk a little bit about causation, and Levin's going to present an experiment he's currently working on. You can interrupt me at any time. You can already, so this is the program. If you already have some questions of a methodological nature, for instance, regarding this little experiment which we did, then just jump in. I want this to be as interactive as possible. And if we don't get through half the slides, I think there's about 200 of them, that's fine. Okay. If we only get through 10, that's fine too. Okay. So are there already any questions, maybe regarding the little survey?
Discuss it at some point?
We're gonna discuss some. So are there any methodological questions about the survey? We're gonna talk about reasonableness later on. Yeah, there's a question there.
Yeah, I'm not sure if I was, maybe not so much a question but a comment. I'm not sure if I was attentive enough, but when answering the questions, I was wondering if it was mandatory. I'm not sure if I got this, how many groups there were, but I got the conversation about ships and various safety check options. And it wasn't clear to me if it's mandatory for the logistics guy to buy any plans.
Okay, good. So that would
that seems relevant to assessing the.
So that would be a substantial contribution. So later on we talk about this case. In fact, this is based on a famous US case called the T.J. Hoover case from the 30s. And it turned out that for a guy in a similar situation, it was mandatory to install radio equipment so that he could be warned about a storm. I don't know, it was one of the, so there's these little, so it was in the New York harbor, there are these little tugboats, which tug the big boats. So the little tugboat didn't have radio equipment, was tugging a big boat, the storm came, and they all sank, okay, in the harbor of New York. And then a lot of ships already had just ordinary radio, and twice a day they would give like meteorological reports, So our guy, who had this company with a T.J. Hoover and I think another ship, said, look, like hardly anyone has radio equipment. This is all very new or whatnot. But it was decided that he was liable for damages. Okay. So this is an original case, and in this particular case, it was decided that yes, it mattered. So it's sort of like similar. It's not the exact kind of case, but I think it's similar enough. Good, let's get started. So I imagine that a lot of you know about the lobe effect, but I think maybe some of you don't know about it. So if you know about it, then play along nonetheless, okay? And we get to more exciting stuff in a second. But I think it is really one of the most intuitive cases one can find in experimental philosophy or experimental jurisprudence. To set the stage, let's think about criminal responsibility. Here's a sketch, at least in the Anglophone system, what you need are two things: a mens rea and an actus reus. If you accidentally kill someone and you're not even negligent or something, then that isn't that problematic. If you only have an intention to kill someone, but you don't act on it, that isn't particularly problematic either. Okay, what we need are these two elements. And they're conceptually and procedurally distinct. Okay, the reason why they are separated is that we don't want to say, "Oh, he had a really bad intention and something bad happened, so it's probably, it's probably related." We want to make sure that we don't unjustly punish people for a bad accident or just the having of an inculpating mental state. There's different types of mens rea. This differs from country to country. In the US and the UK, it's roughly the following. There's intention, which is the most inculcating state of mind. Knowledge, which is treated as distinct from intention, because sometimes you knowingly do something bad without necessarily having a desire to bring about harm. No? So perhaps the more philosophically inclined in the room know the so-called doctrine of double effect, where you contrast a situation in which there's a very responsible war pilot, okay, and he's given the task to bomb a certain area where the enemy has certain production facilities or so. No? And there's also like children playing, and he knows he will kill the children, but he certainly doesn't want to kill the children. Okay. Contrast that with a terror bomber who just wants to kill as many people as possible. So that guy also knows that he's killing a lot of people, but he also desires to kill these people. Yeah? So we would think intuitively that the latter guy is more culpable than the former. This is why we have this distinction between knowingly doing something that brings about harm and intentionally doing so. We're going to focus on these two types of mental states perhaps in this block of lectures, and then we'll move down the menu to recklessness, and in particular the much neglected but very interesting, very important mental state, or absence of a mental state, negligence. So negligence is defined as someone acts negligently if she should have been aware of a substantial risk. Okay. So the problem is precisely not that she had a mental state, but that she didn't have a certain mental state. But her mind was also in a kind of state, so it, then you can be like pedantic about it, but it also, like, I think it's appropriately classified as a mens rea. Good. So here's a standard view of intention. This differs a little bit across countries. Like the more legally savvy in our team, like Levin and Isa and Jan, for instance, have told me that this is very different in many countries. I think if I'm recalling correctly, in France they have 5 different concepts of intention. Okay, so that makes everything very complicated. In Switzerland and Germany, perhaps also in Poland, there's this interesting distinction sort of happening at the level of recklessness, no, dolus eventualis, sort of known sort of conscious recklessness or like unconscious recklessness. Here's perhaps what most people would intuitively understand as a good definition of intention. Did the agent have foreknowledge about the outcome? I mean, it seems to be a necessary requirement to know what you're doing, to act intentionally. If the answer is yes, then we ask, did she desire to bring about the outcome? If the answer is again yes, then it's intentional, and if the answer is no, then it's not intentional. So those of you who have read Bentham would go, but under certain conditions, you can act intentionally only, like if you act knowingly, you don't actually also have to have a desire. That used to be, if I'm rightly informed, that used to be a going definition in British law. Then it changed to a more demanding, non-Benthamite concept of intention. Henny has written a lot about that, and apparently that's changed a little bit back again. So, like, as long as Nevin is nodding along, I think I'm on safe grounds.
I'd say that the first one is, did the agent have or should they have had foreknowledge about it? That's how it would be understood.
Interesting. So you would make it, but wouldn't that be? I mean, that's a big difference, no? Should they have had foreknowledge? I mean, that for me is rather in the negligence, recklessness. So the reasonable person would have had foreknowledge. So maybe you should have had foreknowledge, but you actually didn't. So then we would really talk about intention, right? Because we're really talking about throwing you into jail for 20 years, more like in the US for like death penalty and whatnot. No, but this is not the kind of case if there's like, we could have expected from him that he should have known or something. Good. Okay, so for those of you who know the note effect, this is some probably familiar territory. For those of you who do not, please consider the following case. Okay, the vice president of a company says to the chairman, "We are thinking of starting a new program. It will help us increase profits, but it will also harm the environment." The chairman responds, "I don't care at all about harming the environment. I just want to make as much profit as I possibly can. Let's start a new program." They do start the program, profits go up, and the environment is harmed. Okay. So now consult your own intuition. You can only respond with yes or no. Okay. So the question is, did the chairman harm the environment intentionally? Okay, so now let's all take like a second. What would you say?
Well, I answered you already, but I'd say it's almost as it was. Yes, yes.
And you would say yes.
Not criminal lawyer, but under Polish law, that would be probably dolus and wives.
Yeah. But you were really, I mean, okay, so that would be sort of recklessness. No,
I think we make a distinction between we have dolus directus, those who want to kill you, and dolus eventualis, but they don't care whether you will be killed or not.
Exactly.
So that would be dolus eventualis. I anticipate the outcome, but that is not my intention to kill. I just don't care.
But here we're talking about dolus directus. I mean, we're talking about the top mens rea.
Yeah, so that's not dolus directus, to my mind, but that's a matter of criminal laws. I'm not quite certain.
And we're just trying to get your juices flowing a little bit. Okay, so here's an alternative scenario. The vice president says to the chairman of the company, "We're thinking of starting a new program. It will help us increase profits, and it will also help the environment." Okay. Chairman says, "I don't care at all about helping the environment. I have no desires with regards to the environment. I just want to make as much profit as I can. Let's start a new program." They do start the new program. Everything occurs as anticipated. Profits go up and the environment benefits. Okay. So I see some people nodding a little bit. Did the chairman help the environment intentionally? So in the first case, maybe it was, I mean, if you're not, you're not a professor of law, who's like very careful, goes like, okay, I won't fall into the trap. Yeah. When I would sort of like to describe intentionality here, yeah? Whereas here you don't. Okay. And this is sort of when you ask lay people. This is a sort of study by Joshua Knoll, who sort of is the founder, presumably, of experimental philosophy. The proportions of people who said yes, who did it intentionally in the harm case are about 80%. Okay, with lay people, and in the help case, it's only about 20%. So this is astonishing because we would have thought that intention matters for moral or legal assessment, but morality doesn't matter for whether there was an intention or not. Okay, I mean, intentionality, we would have thought, or most like philosophical and legal accounts of intention, perhaps with the exception of Bentham and Gilbert Harman and a few other people, we would have thought that the attribution or the concept of intention is or should not be sensitive to moral valence. Okay. Naturally, your moral judgment changes if there is intention, but if if the outcome is good or bad, shouldn't matter for us detecting the morally independent mental state of intention. So see so I showed you the standard view of intentional action. Now we have an alternative view, according to which, this is interesting. You actually see my notes, which I'm not even using, so I'll take them away so you think. So you think what is actually the case, that I'm talking free. Did the agent have foreknowledge about the outcome? So this is intentional action according to these findings of Joshua Knoll, okay, which have been read as probably no study in experimental philosophy or moral psychology over the last 20 years and has been replicated as many times as this one. Okay. So did the agent have foreknowledge about the outcome? Well, I mean, he clearly knows that the environment is going to suffer or benefit. No? So that's a yes. And now, we're not looking for a desire, because the guy explicitly said, I have no desire to harm the environment. Quite to the contrary, we look in somewhat consequentialist fashion to the outcome. Okay, was the outcome good or bad? Well, if it was bad, we say it's intentional. Pretty much exactly what Bentham said. If it's good, it's deemed not intentional. Okay. Okay, interesting. So there was, I mean, as I said, there's about like 100 to 200 studies on the Nope effect. When I started reading these, I thought, do we need like yet another 10 or 15 studies on this, or should we make this a little more relevant? And I think it is very relevant in the legal context, where at least in certain jurisdictions, knowledge is not sufficient for intentionality. Okay. So for instance, in the States, you make this distinction, this hard distinction between knowledge and intention. And if you intentionally kill someone, well, I mean, the consequences can be extremely dire for you, like death penalty and whatnot. But if you knowingly do so, I don't think you're a death penalty candidate. Okay. But the folk go, knowledge is sometimes sufficient for intentionality, namely when the consequences are bad. And other times it's not sufficient for intentionality. Then we would also go to desire. Like we'll look for a design. Okay. Is this clear so far? This is sort of a safe setting. So there's a mismatch between the folk concept of intentionality and the law. They seem to use different concepts of intentionality. And there's therefore, like, who decides, whether an agent acted with intention in the US or in the UK, possibly in Canada, I don't know. Well, quite often, lay juries. Okay. So the court assumes one concept of intention, outsources the decision to the folk, but the folk come into the courtroom with a completely different concept of intention, maybe the morally sensitive type, and that could potentially lead to a lot of injustice. So there's two, what do you do if you have this mismatch of the folk concept? The folk concept figures prominently in lay juries considerations, I imagine, and the legal concept of intention. There are certain people like Anthony Duff and Julia Kubik, who's a lawyer. She published a couple of papers on this topic, who say, well, the folk concept is correct, and the law must be changed. Okay. Basically, this distinction between knowledge and desire is perhaps artificial. Bentham was right. Sometimes, according to Kubik and Duff, maybe the UK is on the right side of say, folk conceptual analysis of intention. Sometimes it's not. Other people like Nadelhofer and Adams say the folk concept is biased, and the folk is simply unfit to judge in criminal trials, in these countries where you have a solid distinction between intention and knowledge. So this is how I got into this. I went like, this makes a lot of sense, and here finally we have we have an interesting case. Like, okay, so how much interest is there to like figure out what really, what intention really is? I don't know, but if it matters a lot for the law, then here's an interesting application of the Nope effect. And one potential solution, if you stand a little bit, in the camp of Nadelhofer and Adams, is to say, let's abolish lay juries, and have experts judge criminal cases. They presumably get it right. No? And we just had an example of the professor saying, no, not intentional. It's dolus individualis, but it's not dolus directus of the first degree. So that was my high hope, to find amongst the experts basically a complete refutation of like a non-occurrence of the Nope effect. So I ran this with professional judges, 36 professional French judges. They had an average experience of 18 years. The vast majority was at a court of first instance, 25% at a court of appeal. They gave different professional specialization. So most of them focused on criminal law. You see, it's not very many, 36, you know. It was a complete nightmare to get that many already to fill in a little scenario. And I gave them the German scenario in French, and I ran it in a within subjects design. Okay? Just as we did it right now, I gave them both scenarios, okay, and I manipulated the order. You know, so some people got the good case first, some people got the bad case first. Here you see the results. Basically, the judges did even worse. They did even worse than the lay people. So in the harm case, more than 80%, like 83% or something, said, yeah, he did it intentionally. You know? And in the help case, it wasn't even 10%. Okay. Yeah.
I was wondering if this can be I haven't seen the results for the no effects in French. I was wondering if this is something to do by any chance the fact that you
yeah. So staring at it, I think so. The layman data here is from Josh's paper. So that's lay people data from the US, but I also ran it with lay people in France, and it comes off the same. Okay. Also, I mean, I don't want to make a big difference of the fact that, you know, the judges do a tiny bit worse. This is probably not statistically significant here, you know. I mean, basically the red bars are the same, you know, and the blue bars, who cares? They're a little different. But the frightening thing is that we have a perfect replication of the lobe effect amongst very experienced judges. Okay. And here's something, I mean, here's something particularly interesting. I mean, how can it be that you give these two scenarios to people? So if, you know, those people who got harmed first, said in 84% of the cases, yes, he did it intentionally. Okay. Now these people have a lot of legal training, you know, like on average 15 years of experience. And then you give them the help case, and that doesn't jolt them out of their, you know, out of their reputation. They say, actually, in the help case, he didn't really do it intentionally. Since this was within subjects, so people saw both scenarios, I think it's particularly frightening. You know, if you give people only one of the two cases, fine, you know, but they saw both, you know, and they didn't aim for consistency or something, you know. Yeah.
Are you trying to say it's some kind of mistake or a bias? Or?
I'm going to argue at length for that. Yeah. Okay. I mean, it's certainly a mistake from the legal point of view. You know, not from every legal system's point of view. So as I said, you know, if you have a Benthamite concept of intention, so Bentham says something like, if you knowingly do something which is bad, even if you don't desire it, then it's done intentionally. Okay. So sometimes over the last century, that was a running definition of intention in the UK. Sometimes it changed to something more demanding, where you need knowledge plus desire. Okay. In France and in the US, and I don't know, currently in the UK, yes or no? No.
UK is Benthamite.
At the moment, it's Benthamite. But in the 50s, 60s, 70s, it was not Benthamite. No? Okay. So like in the 70s, this would have been a mistake in the UK. Currently, it's fine. Okay.
Can I just ask, like,
yeah, absolutely.
I'm just wondering, like, about the sort of symmetry here. So, like, how often does it matter if you had good intentions or not in the law? Like, how often do judges actually have to care about that? So if we're talking about helping the environment, if the CEO really wants to help the environment, well, what does it matter legally? How often are judges encountered with that question? So bad intentions matter, but good intentions don't matter that often.
Exactly. So Lisa's point is like, look, the courts only like deal with bad cases when, you know, they don't give out medals, okay, for like exemplary behavior. No? So does this matter at all? I mean, of course it matters, no? Because if I mean, what we said before, if there should be a distinction in culpability between knowledge and intention, but whenever something bad happens, which is the only reason to take you to court, you know, people will instantly ascribe intention if they detect knowledge. I mean, then there's a significant overascription of intentionality, you know. So this might not currently be a problem in England, where, Dolus directives of first degree and second degree are basically collapsed. Okay.
As well.
But in most systems where you make this distinction, and this is sort of relevant because, intention is the most inculpating. This leads to like considerable punishment, or like the most severe punishment. And if you just go, okay, there's one thing like knowledge, just knowledge, or those directives of second degree, we don't care so much about it. Basically, we're hardly ever gonna describe it or attribute it. Then that is very unjust.
But what if you then presented the test subjects with this distinction between those?
We're going to get to that. So we're going to focus on intention and knowledge. Just to get you started, but this is an excellent question. Did you tell me that Gideon Yaffe said that? So Gideon Yaffe says, so I agree with you. Okay, so the court's of main importance when it comes to like bad acts. But sometimes, like I think someone said to Gideon Yaffe, actually the court isn't very important when it comes to like good things, so the node effect isn't interesting. I think it focuses on the wrong point, as I just said. But certain people like Yaffe say, actually that's wrong. The courts, for some reason, I can't remember them, are also maybe in mediation or something. So you did something bad, but you're also sort of a good guy. But the fact that you're a good guy isn't taken into consideration, but that you produce a bad result, whatnot, But I think the main point is that people who just acted knowingly will be treated more harshly. That's why it's relevant. Yeah.
So I read some experience of the renunciation defense. So if you, for instance, like do something bad, but it's a crime which depends on the consequence. And so the consequence hasn't yet happened. For instance, you give poison to someone, the poison takes time to start working, and then you give an antidote. And like, if the antidote does not work, then, for instance, in the Polish system, your good intention trying to stop the bad outcome from happening should be taken into consideration. Looking at the case law and at the experiments, it's not. So the bad intentions override the good intentions, even if they're like somehow relevant in the legal rules. And perhaps this also goes to the legal rules on punishment. So like I think good intentions have a lot of importance in the rules on prescribing punishment. And this would be another interesting, I guess, to the extent of being neglected.
So perhaps, they're certainly relevant when like, after culpability has been determined, are there mitigating circumstances? He's an extremely nice guy, but actually he did something bad, so. But you see that this isn't really the point anyways. The point is just, we're conflating knowledge and intention, and it would be perhaps okay to conflate downwards, but we're conflating upwards now. So good. Okay, and if you give people the help case first, they say, well, in 6% of the cases they did it intentionally, and in nearly 90% of the cases in the harmed scenario, we did it intentionally. Crazy, I find. So what does this mean? The node effect is just as pronounced for professionals as for lay people. If the mismatch between the folk concept and the legal concept of intentionality is considered a problem, then simply abolishing the juror system might not suffice. See, originally I got into this with I had a one-paper plan, okay, and thought, okay, there is this node effect problem. I'm going to show that professional judges do much better, and that's it, and that didn't work. Okay. In fact, I ran a second scenario in this original study on the node effect with French professional judges, which was inspired by the following hypothesis, namely, maybe the node effect is by and large misconceived. Maybe it isn't so much about good versus bad. Okay? Maybe it's about the degree of severity of the outcome, vis-a-vis the propensity to ascribe an inculpating mental state. Okay, so the hypothesis was the more severe the outcome, if you keep the mental states and all the circumstances fixed, the higher the propensity of mental state is to keep. Okay, So consider a situation in which Isa and I go to the museum, it's an ethnographic museum, and we say a paper just got accepted, so we do like a little monkey dance in the lobby. And we always do when a paper gets accepted. So we fool around like in the lobby, and each of us knocks over a vase that is sort of standing around. Okay, so Isa's vase is just like a decorative vase from IKEA, with some flowers in it. Value 15 euros. Yeah. And the vase I'm unfortunately knocking over, like doing the monkey dance, is an old Ming vase of unfathomable value. They can't even be quantified. What do you expect is going to happen in court? My hypothesis is that I'm going to be ascribed negligence or recklessness, whereas Isa can just go. So the more, like, everything is the same, like our behavior is the same, whatnot. It just so happens that the vase I knock over is extremely valuable, so the damage is very, very large. So the question then was, if we leave the noble effect behind, we have this interesting hypothesis that it's really about severity of outcome and not so much about availability, good versus bad. The question was, do lay people or jurors manifest the severity effect in intentionality ascriptions? And here we come to one of the points that was raised. Does this also work for knowledge ascriptions? No? Because maybe you can argue what the right concept of intention is. But I don't know of a single epistemologist who says whether or not you ascribe knowledge should depend on, whether the outcome is good or bad. So, that is patently, there is no Bentham in epistemology. Okay, there's just no such account. Okay, so here's a case. 180 participants, and this was the scenario, very similar to the one you've already heard at the beginning of this lecture. A mayor wants to build a new highway connection to improve traffic. He is aware of the negative side effects on the environment, but does not care about them. And there's, a severe condition of permanent damage where the animals in the construction zone die and they won't come back. Basically, you're like really destroying the fauna and flora. Or reversible damage, where the animals are temporarily disturbed, maybe they don't reproduce as well and as healthily during the construction, but they don't leave and they don't die. Okay, and like after a few years, everything's back to normal. Yeah. I think this is is the second case actually a harm case? It is a harm case. This is sort of based on a Supreme Court case, I think, where people wanted to. They wanted to get wood out of the forest, and there was this protected bird, whatnot, and then they couldn't do it because the bird was being removed, to just disturb that bird, So this disturbing animals is considered a harm. Okay, killing them, of course, is considered an even worse harm. So here's the full scenario. If you're interested, we can come back to this. People were asked. So they were presented with one of the two conditions, either the somewhat bad case where the animals are disturbed for a while, and the really bad case where there's permanent damage and things won't get back to their original state after construction has finished. People were asked on a scale of 1, completely disagree, to 7, completely agree. To what extent do you agree with the following claims? First, the mayor intentionally harmed the environment. And now we bring in this sort of other mens rea knowledge. The mayor knew his action would harm the environment. And thirdly, the mayor deserves blame for his action. Here are the results. So you see here the scale starts at 4, of course, it goes all the way down, but you see the difference a little better like that. For knowledge, we get a significant difference. Okay, so if it's the blue bars are reversible damage or not so bad, but somewhat bad, but not so bad. The red bars are really bad. Okay, so you see a significant difference for the ascription of knowledge. Did he know he would harm the environment, or like the animals. Well, if it's not so bad, people go, yeah, he sort of knew. It's really bad, they go, absolutely, he knew. Okay, we're basically at ceiling. You see, out of 7, we're at like 6.8. So you see, there is a severity effect not only for intentionality but also for knowledge. You know, and here really, I mean, that's crazy. You know? There is no account that says the ascription of knowledge should be sensitive to moral concerns. We get a pretty good effect for intentionality also, and a very powerful effect for blame. So one hypothesis when you see something like that is the following, that maybe some of you know the psychologist Markus, who just unfortunately died a few months ago. He says, look, people are blame amateurs. Okay, so what they do is they see something bad happen, and then they go, he's as to blame, and then post hoc they attribute everything they need to justify that blame judgment. Okay, so if you remember, like we said, the legal system, and also, like, you know, most philosophers or moral psychologists said the kind of thing that we want to go on is we look, is the person causally responsible for it? Did they do it with knowledge or intent or something? And then we blame, you know, or ascribe culpability. Aliki says, well, it's unfortunately going the other way around. Okay, first we blame, and then we go, since we have an inclination to blame her, now we also need to ascribe a mental state. You know? So there's some. So this is the kind of hypothesis. There's basically, and here we're coming to the bias, you know. So certain features of the actus reus, namely the severity of outcome, is driving blame attributions, and then sort of post hoc people ascribe the kind of mens rea they need in order to justify the blame attribution rather than the other way around. Okay. And then you go like, okay, can you give us an argument for this? So far, it's only hypothesis. Well, what you can do statistically is the following. This is some kind of analysis. It's not causal, it's relational, so it's not super, like it's not foolproof, but it's a first indication. Okay, there's this kind of analysis which is called mediation analysis, where you say, and I'm going to explain this a little bit here. Say, you know, if you see there's a relation between the grades of a student, you know, whether they could get good or bad grades, and well-being. Yeah. You see, you measure this over like the course of the semester, you teach a bit, and you see, you know, the students who get good grades are happier than the students who get bad grades. And you think that grades, you know, and of course as a teacher you're sort of happy about this, you know, because then that builds an incentive to study harder. You think, there seems to be a direct relation between the grades and well-being. Okay. But then you also measure self-esteem, for instance, and you realize actually good grades increase self-esteem, and it's in virtue of the self-esteem that people are happier. I mean, people with a lot of self-esteem, self-confident people tend to be happier than people who are like a little non-confident. And then you can run an analysis and you say, right, well, if we take self-esteem as a mediator into account, is there still a direct relationship? Do grades as such have an impact on well-being? And that analysis sort of tells you yes or no. And in this case, for instance, I think this is an actual study. It seems that all the effect travels from grades to self-esteem to well-being, and there is no, you know, if you have people of the same self-esteem, there is no difference in well-being directly occasioned by the grades. Okay, so this is how mediation analysis works. Let's come back to the hypothesis we had before. So if we have a moderate versus severe side effect, you know, if the animals are temporarily disturbed versus they're like, you know, getting killed or not, we have seen that impacts blame. Okay, we see a very strong, you don't have to like bother about the 1.44 and so forth, but in any case, it's like strongly significant. So we see that impacts blame, And we know it also impacts intentionality, but once you use blame as a mediator, you see there is no direct effect of outcome severity on intentionality. Okay. Why do you see that? Because before it was significant and now it's non-significant if you put in blame as a mediator. Okay. So, you know, is this the last word on Alicki's sort of bias interpretation of these kinds of things? No, it isn't. There is some evidence, correlational, causation evidence that this might be on the right track. And you get the exact same picture for knowledge. Okay. So blame also is a significant and complete mediator for the relation between severity of outcome and knowledge. It's not severity of outcome, which has a direct effect on knowledge. It is mediated by a blame. So people seem to perhaps blame first and then look for the appropriate mental state. And knowledge, this is not particularly surprising. I mean, since knowledge is a necessary condition for intentionality, is also a complete mediator for the relation between severity of outcome on the one hand and intentionality. Okay. So, you know, talking in words, the asymmetry in intentionality description seems to be driven by knowledge description, which in turn are driven by blame. Okay. So what happens is, if we have two different outcomes, we sort of jump to blame conclusions. In virtue of higher or lower blame, we are more willing or less willing to ascribe knowledge. Since knowledge is a necessary condition of intentionality, this trickles down to intentionality too. Good. So, you know, this kind of hypothesis, I think that a feature of the actus reus, which should not impact mens rea description, does actually impact blame, and blame filters down into mens rea attributions, and this whole process that badly distorts the establishment of criminal responsibility. Are there any questions regarding this? Also, you can also ask, like, I know I'm throwing a lot of like stats stuff at you, but you only have to have a vague understanding of it. Are there any questions at the moment? Yeah.
I have a general question. Maybe it would be better to say it.
No, let's see.
Okay, because I had an experience with the test from the notes effects. I done it for myself, and I didn't know the context. So I figured out that in both cases, I felt that it was intentional. It was intentional harm and intentional harm. Because in my this was described as an ethical question. But if I think that if it were posed as a criminal question, I would answer in a different manner. So I have a question whether this is not like mapping the answers to ethical questions for problems from criminal law. Maybe people would answer differently if it would be in the context of law.
That's an excellent point. So I have a general answer to that, and I have also like an experimental answer to that. The general answer. So when I presented some of these findings in the Cour de Cassation, which is the highest court in France, and I thought they would be furious about like the negative image, but they were just all laughing, going, oh, you know, like this is not really a problem. We don't actually make mistakes in court. You know? And you go like, what? So here's what. Okay, so at the time I didn't have I also have an empirical response to your question. But at the time, what struck me is the following. You know, so if you have a lot of you study philosophy or law, so you're conceptually very precise. No? So if you go out of the street and ask people what is truth or something, they say the most astonishing things. So they say things like, truth is beauty, or truth is God, or something astonishing. And you, as a philosopher, have of course thought about what truth is. So I find it extremely weird that you would go into the street, you know, when you leave the philosophy department, and you would also like return to like confused definitions or astonishing things about what truth is. No? No, you leave the philosophy seminar and you go, even in the street, truth is the property of a sentence, yeah, or representation or something, depending on what your account of truth is, you know. So now we have these people who've been judging cases where the central question is, you know, they've been judging them for like an average of 15 years. The central question is, what is, like, was it intentional or not, you know? And then they leave the court, you know, and go, now we're sort of back to this, I don't know, you know, this other kind of thing, you know, which is like extremely lofty or like hard to define, even though we've just used a very precise concept of intention, of which we presumably convince. You know? So I find that highly astonishing, you know. The you can jump in a second. So I can maybe over the lunch break also throw in some new data with maybe some of you know this guy called Chris Publitz, who's a legal philosopher, legal guy from Hamburg University in Oxford. And we ran some experiments where we gave legal experts the precise word, you know, we gave them the menu as it would like appear in a legal concept. So is it dolus directus or first degree, dolus directus or second degree, whatnot? You find a brutal no effect there too, you know, amongst professionals working with their own tools, you know. So yeah, you know, so these are the two answers. Okay, so maybe this concludes it nicely. Okay, so what I showed you was lay data. So I said, you know, this is like if the Knob effect and the severity effect, you know, so it isn't maybe the Knob effect is actually completely misunderstood. It is actually a severity effect. I showed you lay people data with regards to knowledge and intentionality descriptions. I showed you the mediation analyses. Do professional judges manifest this kind of effect? The severity effect, that the worse things are, the higher the propensity to describe intentionality. And I sampled another bunch of French judges. Interesting, 10%, 9%, so about 3, were at the highest court in France. You know, so I didn't check their individual responses, but this is sort of a rock star sample. They again got this kind of vignette about the mayor, you know, and sometimes the birds are like hurt a little or permanent damage. They die, they won't come back, you know, like the birds leave for another, for greener pastures, you know. People were asked, to what extent do you agree or disagree with the claim that the mayor harmed the environment intentionally? And here you see the results. So, you know, if the birds were just harmed a little bit, people said, yeah, he didn't really do it intentionally. You know, if they die and don't come back, they all said, yes, he did it intentionally, you know. And what you also see here, so if you look at the midpoint 4, you see that we are, or you take it on trust, maybe. You take it on trust that we're significantly below the midpoint. So this is a clear yes. This is a clear no. You know, no, he didn't harm the environment intentionally, but the effects weren't particularly bad. But in the other case, we're so far above the midpoint that this can be interpreted as a clear yes. Okay, yes, he did it intentionally. You see these like the weird little bracket, you know. If that doesn't touch the midpoint, then it means we're significantly above or significantly below. Okay. And you also see we have a Cohen's-d of 1.06, which is that is a large effect. You know, this is not a joke effect. It's like it's not a very large effect, but it's a large effect. Okay, so severity of outcome has an impact on folk descriptions of different types of mens rea. And it is not evident that abolishing the juror system helps, because professional judges also manifest the severity effect with respect to intentionality, even though there's the qualification we still have. So we have several qualifications to address: the bias question, the cross-cultural question, and the context question that was raised before. Okay, so this wasn't, I mean, these people knew that I consulted them on the basis of their legal expertise, but I didn't give them the mens rea menu. Okay, so they were just answering the question as posed there. Cool. So maybe we leave it here, and like I'll get back to Lisa's question as to cross-cultural findings after the lunch break. Thank you.